The NSA's bulk collection of Americans' phone records is not only a gross intrusion on our right to privacy, it's an ineffective intelligence tool and doesn't even comport with the text of the Patriot Act. It is high time that it end.
Traditionally, the Fourth Amendment has been construed to only allow for a probable cause-based specific warrant to go after a specific suspect. The Section 215 metadata program is a programmatic warrant, which means essentially it's scooping up data on every American without any kind of particularized suspicion. And that is the Fourth Amendment violation that we're talking about here.
Think of everything your telecommunications metadata reveals about you. Have you been in touch with a divorce lawyer, a suicide hotline, a substance abuse counselor? If the Constitution does not bar the totally indiscriminate collection of that kind of sensitive data, the Fourth Amendment really becomes a dead letter in the 21st century.
God forbid tomorrow morning we wake up to the news that a member of ISIL is in the United States, and federal agencies need to determine who this person is coordinating with to carry out a potential attack within the homeland.
When this program was first disclosed, we heard dramatic claims about how it had foiled dozens of terrorist plots. And if you adopt a faith-based national security policy like Marco Rubio and Jeb Bush, you pretend that we haven't learned anything since then.
And one of the tools they will use is a tool that allows them to see the people they've been calling and interacting with, so we can disrupt that cell before they carry out a horrifying attack that could kill millions of people.
It's never worked. We know that because the Senate Judiciary Committee found that, the Privacy and Civil Liberties Oversight Board found that, the President's Review Group on Surveillance Technologies and Communications found that. Does not work.
The board concluded that the Section 215 bulk telephone records program lacks a viable legal foundation under Section 215, implicates constitutional concerns under the First and Fourth Amendments, raises serious threats to privacy and civil liberties as a policy matter, and has shown only limited value. As a result, the board recommends that the government end the program.
Unsurprisingly, the Privacy and Civil Liberties Oversight Board found that if you're trying to find a needle in a haystack, gathering more hay doesn't help. The NSA program was effectively redundant. It was only giving FBI information they'd already obtained using targeted specific orders for suspicious numbers.
Senator Leahy asked NSA officials,
how many cases was Section 215 bulk phone records collection critical to preventing a terrorist plot?
There were 54 plots that were disrupted over the life of these two programs.
And Section 215 was critical to preventing?
No, sir.
They then tried to claim that 13 had a nexus to the homeland.
In the sense of, is there a but-for case to be made, that but-for 215, those plots would have been disrupted? There is an example amongst those 13 that comes close to a but-for example, and that's the case of Basali Moalim.
I've read that. I've read the material on that.
Except it had no connection to the United States. So we went from 54 to 0 in less than 5 minutes. One of the more amazing things about this debate over Section 215 of the Patriot Act, and specifically the metadata program, is that multiple bodies now have said that it's either illegal or unconstitutional, yet Congress is on the verge of reauthorizing it.
A federal appeals court recently confirmed what common sense and even Patriot Act co-author Jim Sensenbrenner have been saying all along. This is not an authority Congress meant to grant.
I have been a vocal critic of dragnet collection as a gross invasion of privacy and a violation of the relevant standard in law.
The 215 telephony program is just one piece of the vast surveillance machine Americans have been learning about in recent years. But it is the one piece on which there is an extraordinary degree of consensus on both legal and simple effectiveness grounds. This is an intrusion we do not need to keep America safe. This form of bulk collection must end.